Hello everyone. Good evening. Can you all hear me? Good evening. All right. Good evening. Thank you, goodness. Good evening, everyone. Welcome to today's session. Uh, Welcome to today's session. We are happy to have everyone in class. Right. Thank you so much for joining in. Thank you for sparing out time to be a part of this session. Please, if you kindly know friends who are in the group but are not yet in class, please kindly reach out to them so that they can join in for the session. We have officially started. You can drop in your subgroup a notification saying that class has started so that we can have a full class. So, good evening once again. My name is Dennis Williams, and I'll be your moderator for today's session. So in today's class, we are in week 5 of the third and fourth quarter of 2024. Right, we've gone through week 1, week 2, week 3, week 4, and now we're in week 5. We are close. We are shortly coming, or we are at the peak of the program in that sense. We are almost rounding up with the program, and I don't know how it has been for you, right? But for me, the program has been refreshing. Even as the moderator, as the coordinator, I've gotten the opportunity to learn quite a lot from our mentors, and I'm sure you have as well. So moving forward in today's session, our topic, rather what we'll be doing today, in the last class we had a mediation simulation. In this class we'll be having an arbitration simulation, right? And I expect that both groups are already on call. The group 1 and group 2 who will be participating in the mediation simulation are already on call, and they are ready for their simulation. Please, we do not want the instance where a group will be present and will not be able to present in class. So kindly take note of the fact, group 1 and group 2, kindly take notes that your presentation is mandatory and it is important, right? In today's class, we expect some of our mentors to help us run through, to just give feedbacks to our simulation, answer questions, and also help us just help us give further understanding to the arbitration process and what arbitration is all about. And those mentors that will be expecting me to this class for that is firstly, Mr. Nyacham Nawan, right? I don't need to do any really need to do any introduction of Mr. Nyacham. Mr. Nyacham has been with us right from week 1. He has been amazing, and it has been wonderful learning and hearing from Mr. Nyacham. Thank you so much, sir, for joining. I can see you already on call. You're welcome, sir. Thank you so much. Our next mentor that we're expecting in today's class is Mr. Toyid Amuda. Mr. Toid Amuda is another mentor that has been with us in one of the sessions. I'm not very certain of his presence in class today, but we hope he'll be able to join us in today's session. Thirdly, we'll be expecting Mr. Samuel Orobusa Osarere. Mr. Samuel has also been with us in several sessions. I am hopeful that he will be in class later on during the session. So just kindly help us give feedback to our simulation and just help us run through questions and things we may have in regards to what we'll be dealing with today. Thirdly, we're expecting Mr. Joseph Shaidon. Mr. Joseph has also been with us in one of our sessions, and we are very, very optimistic that he will be with us also in this class. And then I think last but not least is Miss Mispa Awasum. Miss Mispa has also been with us in one of our sessions. We look forward to having her also in today's class. Thank you to our mentors for everything that you do for us. Thank you for always sparing your time and always being accessible. We do not take your presence here for granted. But just before we start today's class, remember last week we started announcing about the JIIPCC Academy Free Legal Clinic, right? And we said that the free legal clinic is for creatives, entertainers, athletes, innovators, and startups, right, where they get the opportunity to have a 20 minutes consultation slot with our professionals. And I remember saying that our professionals are a group of world-class a group of world-class lawyers who have decided to offer up their services for absolutely no charge. They want to help you review your contracts. They want to give you legal advice. So please, I would like to ask that you take full advantage of this opportunity that we are making available. This is the registration link on the screen. You can also reach out to me if you need further guidance about the process and what you need to know. And then you can also help share the flyers. You can reach out to me, get the flyers from me, and you can help spread the word. Send it to your friends, to your colleague, those you know may be in need of legal counsel. You can just help us spread the word. So thank you once again. Like I said, we'll be moving straight to business. What we'll be doing today is simulation arbitration, our practicals for simulation, our practicals for arbitration simulation. So before we take or receive our mentors, right, we'll just want for both groups to kick off their simulation, right? We want to start with group one, right? So group one, if you're on the call, you can kindly, those members that will be representing group one for the simulation, you can kindly turn up your mic, tell us what roles you'll be playing, turn on your mic, tell us what roles you'll be playing, and you can just by the side edit your name to just accommodate the role you are playing, right? So thank you. Group one, please, if you're on the call, kindly do that so that we can start the simulation immediately.
Good evening, sir. Please, can you hear me?
Yes, I can hear you. Good evening, Goodness.
Good evening. Okay. Thank you.
Yes, so
my name is Abba Goodness Ojonoma, and I'm a participant and I'm playing the role of the arbitrator, and I'm a member of Group 1.
All right, thank you so much, Goodness. So can we have the other members of your group also introduce themselves, and so that we can get the arbitration going? Please, we want to make it as fast as possible so that we can get to the second group, and then we can also have feedbacks and then questions from the mentors. So
good
please,
evening, everybody.
Yes, good evening. So Fumi.
No, this is Chukwudumebi.
Oh, okay. Oh, sorry about that.
My name is Chukwudumebi Ononye, and I would be playing the role of the counsel to the claimant.
All right, thank you, Chukwudumebi. So please, where are the rest of the members of the group? Please, you can kindly indicate. Do we have the rest of the team on call? Please, we're kindly waiting for you. Please, if you're on call and you're a part of this simulation for group one, please, you can kindly unmute and tell us the role you'll be playing. Chukwudumebi and Goodness, how many members of your team are we expecting in this? Are we expecting in the simulation?
There are actually 3 in number, so one more person is left. We are trying to reach out to the person.
All right. So while we're waiting to have that, please can we? Okay, while group one takes time to get all their participants on call, right? We will not want to waste time. So please, let's move over to group two. Group one, please, you can kindly sort out yourself while maybe group 2 can start their simulation. So group 2, over to you. Please, can we have your simulation? Can you unmute yourself, turn on your videos, tell us the role you are playing, and then eventually start the simulation?
Good evening. My name is Odeyemi Mary, and I will be taking up the role as the arbitrator.
All right, thank you, Mary. Do we have your other team members on the call? Please, for those in group 2 that are participating, please, you can turn up your mic and then introduce yourself. Abigail, we can't really hear you. Your network seems to be a little bit poor, right? Okay, you can turn off your video and try again. Turn off your video and try again.
And I'll be
Your network is still a little bit bad. All right, so please, while Abigail is trying to fix her network, can we have the other participants?
All right, good evening.
Yes, good evening, Mr. Issa.
Yeah, my name is Issa Emmanuel Garba, and I am the claimant in this case.
All right, thank you so much, Mr. Issa. So who else is left for your group?
Good evening. Good evening, everyone.
Yes, good evening.
My name is Kehinde Adegbemiram, and I'm the claimant's lawyer in this case.
All right, so is that all of you?
I'm Leslie, and I am the respondent.
All right, thank you, Leslie. So please, you can go ahead. Arbitrator, over to you. You can go ahead and start the simulation.
Okay. Good evening, everyone. I would like to welcome you to this arbitration section regarding the disputes between Mr. Musa and A and B company. My name is Odeyemi Mary, as I've said before, and I'll be the arbitrator for this matter. Before this session, we have done a preliminary hearing in the past, and it has been concluded. Terms of reference signed, as well as the procedural order, declaration of conflict of interest, and so on. The purpose of this session is to hear both parties. Sorry. The purpose of this session is to hear both parties' arguments and evidence regarding the claims made by Mr. Musa against A and B company. Okay. The arbitrator and secretary undertake to keep confidential awards in the arbitration, together with all materials created for the purpose of the arbitration and all evidence produced by either party to the proceedings, not otherwise in the public domain, save and to the extent that disclosure may be required of a party. The parties must arbitrate in good faith and cooperate with each other and the arbitrator. Also, this proceeding is governed by the Arbitration and Mediation Act 2023. Let's begin with the introductions, please. Please state your name and role for the record.
All right. And I'm the claimant in this case.
Thank you. The claimant's lawyer, please state your name for record's sake. Hello? Okay, while we are still waiting for the connection, the respondent's representative, please state your name for record's sake.
My name is Joe. I am the legal representative for AMB.
Okay. I hope I can still be heard.
Yes, we can hear you.
Yes, I can hear you.
Okay. For the opening statement, during the preliminary hearing, parties agreed to speak through their legal representatives. So the parties can give their opening statements. I will start with the claimants.
Can you hear me?
Yes.
Thank you, arbitrator. We're here today because Mr. Musa was offered employment with A&B Company, which he accepted and subsequently resigned from his previous job in Abuja. Unfortunately, due to the lockdown imposed by the Kaduna government, Mr. Musa was unable to commence work and has not received his salary for the past 8 months. Here are the reliefs which the claimants will want. Firstly, an award ordering the respondent to pay the claimant all outstanding arrears of salary for the past 8 months. Secondly, an order to the respondent to pay the claimant 20 million naira in damages due to the distress caused by this situation. Thirdly, an order to the respondent to pay all the costs and fees of arbitration paid by the claimant. And lastly, an order to the respondent to pay interest in all the above-mentioned amounts as of the date these amounts were due until the date of their effective payment.
Does the respondent representative have anything to say about it? Respondent representative, are you on the line?
Yes, I am.
Okay.
The A&B company contends that Mr. Musa never commenced employment as there was no work opportunity provided due to the lockdown. Therefore, the company believes it is under no obligation to pay any salary or damages. The respondent requests the following reliefs. First, that the claimant is not entitled to all outstanding arrears of salary, having not worked for the past 8 months. Second, that the claimant is not entitled to 20 million naira in damages due to the distress caused by this situation. The third is that the claimant is not entitled to payment of all the costs and fees of arbitration paid by the claimant. And fourthly, that the claimant is not entitled to interest in all of the above-mentioned amounts as of the date these amounts were due until the date of their effective payments.
Okay. Okay, I've heard you. Thank you very much. Parties had already filed their respective documents. It is time for the presentation of evidence. May we begin with the claimant?
Yes, I will now present evidence to support our claim. First to me here is the employment offer letter. Here is a copy of Mr. Musa's employment offer from A&B Company. Then secondly, the employment offer letter. Hold on a bit. Okay, the resignation letter. A copy of Mr. Musa's resignation letter from his previous job. And a correspondence, which is the communication between the general manager regarding the transition to remote work.
Okay. Are there any objections on the documents by the respondents?
None,
The
ma'am.
respondent, okay, thank you very much. Okay. Does the respondent representative have anything to say?
We would like to present our evidence as well. We have our company policy. In this document, we find herein stated that employees must commence work to be entitled to a salary. Our second evidence is an announcement of the lockdown. This evidences the lockdown and its impacts on business operations.
Okay, thank you very much. Now parties will bring forth their witness for their testimonies. The claimant can call forth their witness.
All right, then. So, first of all, I have been consistent with my job. I have sacrificed all my efforts to be diligent in this job. And in case this court does not know, the HR manager has tried to have a malicious relationship with me, but I refused. So I had to even collect loans from the cooperative society in order to even hire a lawyer that will represent me in this case. That is because I cannot afford a legal representative. And you can also attest to the economic, how it is very difficult for me to even feed my family. And for most Nigerians, it is very hard for us to feed our families. And I am entitled to these areas because I have diligently carried out my responsibilities, and I've even communicated with the general manager. And I don't want to even talk about the impact because currently now I'm finding it hard to even feed myself and my family. So I pray that this honorable tribunal will rule in my favor. Thank you.
Okay. Thank you very much, Mr. Musa. Does the respondent representative have any response to that? The respondent representative, please, are you there?
Yes, I am.
Okay.
All right. Well, my testimony will be about the company's operations during the lockdown. So, as we all know, the lockdown was a very difficult period, especially for business owners. So, it wasn't easy to carry on business operations during this time. However, we still were able to retain our employees during this time and reimburse them to the best of our abilities, even though this was a very difficult period for us. We also testify that Mr. Musa did not work, not for a day during the lockdown period. If he had, then we would have reimbursed him like we did the other employees.
Okay. Thank you very much. Okay. Having heard from both parties, the parties may now adopt their closing statements. The claimant counsel.
In conclusion, Mr. Musa was ready and willing to work, and the lockdown was an unforeseen circumstance that should not negate his right to compensation. We demand the payment of his salary and the damages claimed, as well as other reliefs sought by him, should be granted. Thank you.
Any response, the company's respondents?
Yes, we ask on that the arbitration panel finds in favor of my company, A and B company, as Mr. Musa did not fulfill the conditions of his employment, and thus he is owed no salary.
Okay, thank you very much. Thank you both for your presentations. The evidence will be reviewed and the decision will be made based on the contractual agreements and applicable labor laws. I will issue a final decision within 10 days from today's session. The record of today's proceedings will be made available to the parties in 24 hours. The arbitration session is now concluded. Thank you for your participation. Please await the written decision. Thank you. This concludes the end of our arbitration stimulation for Group 2. Thank you very much.
All right, thank you very much, Mary Odemi. Well done to all the participants, to Isa Emmanuel, to Leslie, to Kehinde, and also to Idowu Abigail. Thank you for the effort and the time you put into preparing for this class and the simulation. Well done to you. On behalf of JIIPCC, we're saying you guys did so well. and that will be decided also by the mentors who will be giving feedback to your session. So we'll be moving on back to group one. We hope that group one is okay. Just before we do that, right? Looking at the weather, right? I would not want it to get very dark before we take pictures. While we are doing this, please, we kindly call on group one rather, to get ready and to ensure that we have their simulation. So please, if you're in a well lighted area, please, you can kindly turn on your video so that we can quickly take up pictures and then we can move on with the class. So please turn on your videos, cameras. Thank you very much. Yes, can we have more people turn on their video? Thank you. Can we have more people turn on their video if that's going to be possible? Thank you very much. Sorry, just a minute. All right, thank you very much. And we are done with that. So please, we're moving over back to group one, right? Group one, it's time for your simulation. Yes, please, if you have your mic unmuted, please, you can kindly mute now so that we can have group ones.
Good evening, sir. Please can you confirm if you can hear me?
Yes, I can hear you. Please, who is speaking?
Thank you. My name is Goodness. I'm playing the role of the arbitrator.
All right, thank you, Goodness. So please, do we have the rest of your group now in class?
Good evening, everyone. Yes. My name is Jessica Tofia, and I'm playing the role of the legal representative for A&B company. Thank you.
All right, thank you. Thank you. So please, who is the last person?
Good evening, everybody.
Yes.
My name is Chukwudumezi, and I'll be playing the counsel for the claimant.
All right, thank you. So please, over to you guys. You have 10 minutes for your simulation. Please go ahead with it.
I'd like to welcome the legal representatives for both parties to this arbitration session. Just like I stated earlier, my name is Abba Goodness Ojonoma, and I have been appointed as the arbitrator from the Settlement House ADR Training Institute to hear and decide on the case between the claimant, Mr. Musa, and the respondent, A and B company. And it is important for us to note that this arbitration comes after a mediation attempt that did not result in a settlement. I appreciate both parties for their cooperation in proceeding with the arbitration process. We are here today to hear and resolve the disputes regarding the unpaid salaries of Mr. Musa, an employee of the A and B company. This session will be conducted in accordance with the arbitration agreement signed by both parties, and I am here to make a fair and impartial decision based on the evidence and arguments presented. But before we proceed, I would like to remind both parties that this is a formal process and I expect full respect for the procedure. Please refrain from interrupting the other party while speaking. And if you have any objections or issues during the session, kindly raise them in an orderly manner and I will address them accordingly. Also note that this arbitration session is confidential. All statements, evidence, and decisions in this process should not be disclosed outside of the session without the consent of both parties, as agreed in the arbitration agreement. But before we begin, are there any preliminary matters that the legal representative for either of the parties would like to discuss?
No, Ms. Goodness.
Okay, thank you.
There is none, Madam Arbitrator.
Thank you. Now we shall proceed with the claimant, legal representative for the claimant to give her opening statement.
Thank you very much, Madam Arbitrator, for the opportunity to address this honorable panel. My name is Chukwudumebi Onoye. I am the representative of the claimant in this proceeding. Like you mentioned, this is an arbitration proceeding and not a litigation. And we are here for the settlement of disputes and to ensure that justice is served and not to have back and forth. So I hope that this proceeding is done properly and ruled in our favor, and justice is served and our disputes are settled amicably. Madam Arbitrator, we are here today before this panel as a result of the issue that arose between my client, Mr. Musa, and his employee, the person of the respondents, that is A and B company. Mr. Musa is a young man who is married with children and was employed by A and B company to resume work on April 1st, 2020. As a result of the lockdown and the restriction by the Kaduna state government, my client, in the person of Mr. Musa, was unable to resume work at that point. Excuse me. Was unable to resume work at that point. Mr. Musa contacted the general manager of A and B company as regards his status of employment. The general manager of A and B company told him that the human resource manager would get back to him as regards the information concerning how he would be able to work remotely. Mr. Musa, my client, and the claimant in this proceeding stayed idle for 8 months without any information given to him concerning his proceeding. Concerning his employment. During that 8 months, Mr. Musa did not receive any form of remuneration, salary, or any form of compensation. This is the reason we have brought this matter to this tribunal to pray or to ask that the tribunal or the following reliefs be granted, that our clients be granted damage of 20 million naira, and for the company to be compelled to pay my client, the claimant in this proceeding, his salary arrears. Thank you very much, Madam Arbitrator.
Okay, thank you, Ms. Fumi. The legal representative to the respondent, do you have anything to say with regards to what the claimant has said and your submission too?
Yes, thank you, Ms. Arbitrator. I would like to say that my client, A and B company, I would like to state some difference in the fact that was stated by the claimant earlier. Mr. Musa was offered employment with A and B company in Kaduna with a start date of April 1st, 2022, but due to the COVID-19 pandemic, he could not resume physically, and he called the general manager to tell him that you asked to work remotely from home. But the general manager actually said that he will communicate with
please, can you put off your video?
My video? Sir? Sorry, sir, please, I did not get what you said. All right, sir. All right, sir. So for over 8 months, Mr. Musa did not render any services to the company, and he has come to A and B company to claim all his salary in arrears and damages of 20 million naira. But I would like to submit my arguments. Mr. Musa did not perform any duty for A and B company, and it did not start at the intended date of commencement. And in our employment contract at A and B, it is expected that a staff performs duty to be entitled to compensation and salaries. And another point of my argument is that, first measure, the lockdown due to COVID-19 pandemic is not a fault from the company.
Talk for me. If you
Yes,
can
sir.
hear me, please. You need to change your location since your camera is off. Just walk to another location.
Yes, sir.
Oh, okay. I think sir, it is from your end. We can I can from my own end I can hear out loud and clear.
I can hear her too.
Sorry, please, can you indicate if you can hear me clearly? Because I feel. So please, sir, can I continue with the presentation?
Yes, please, you can go on. Please go on.
All right, thank you, sir. As I was saying, the COVID-19 pandemic is not a problem from the past. It was not caused by A and B company. And so we should not be entitled to pay salaries for a performance that was not done by Mr. Musa. Another point of my argument is lack of communication. While the general manager claims to say he would communicate with the HR manager, he did communicate with the HR manager based on the evidence adduced from the HR manager. But this internal miscommunication between the HR manager and Mr. Musa is not the fault of the company in any way. Therefore, we are not entitled to pay either the salaries in arrears or any damages at all to Mr. Musa. Lastly, there is no basis for damages for Mr. Musa. This is because he did not perform any form of duty to the company. Thank you, Ms. Arbitrator. Those are my submissions and arguments.
Okay, thank you. Now to the legal representative for the claimant, do you have any rebuttal for all that has been said by the respondents and your submission too? Thank you.
Yes, thank you very much, Madam Arbitrator, for the opportunity to speak again. Okay, so I would be addressing this tribunal based on two issues before this panel. That is the issues concerning Mr. Musa's salary arrears and Mr. Musa's rights damages. It is my humble submission, or this humble submission of my client, Mr. Musa, that he is entitled to salary arrears. This is because of the impossibility of performance of his duty. The impossibility of performance of his duties arose from the miscommunication or lack of communication on the part of the employee in this case. That misconduct or miscommunication from the employee rendered it impossible for my client to perform his duty because he was not abreast with the information and with the information he needs to carry out his duty remotely because of the COVID-19 lockdown. Secondly, looking at the case before us, we can see the issue of force majeure, which is a situation where both parties are exempted from obligations
Goodness,
because of.
I don't know who is speaking. We can't actually hear what you are saying.
Sorry, can you hear me? I forgot to ask. I'm sorry.
Who is speaking?
Yes, we can hear you.
Okay.
I can hear you.
Okay, thank you.
I can hear you.
Thank you.
Hello. Sorry, before we continue, let's confirm for Mr. Nyacham, sir. Mr. Nyacham, can you hear us clearly? Because it seems everybody can hear except you. Mr. Nyacham, are you with us, sir?
I don't know whether it is my own network or the network from the other end. But I can't hear. It's breaking.
Oh, okay. I think it's from your end, sir, because we can hear the group, every member of the group clearly. So maybe you can try and log out and rejoin the call, sir. All right, please back to the person who was speaking. Please, you can carry on.
Okay, please permit me to go a little bit back. I'm sorry about that, because I can't remember where I stopped. Okay. It is the humble submission of my client that Mr. Musa, my client, the claimant in this proceeding, is entitled to salary arrears. This is because of the impossibility of performance of his duty. It is a known fact that in employment contract, that the lack of performance or the non-performance of duty exempts the employee from compensation. However, an exception to this is the impossibility of performance of duty. And in this case, the impossibility of performance of duty was caused as a result, or was as a result of the lack of communication on the part of the HR manager, who is a representative or an agent of his employee, that is A and B company. The lack of communication put my client in a position where he's not aware of the information and all the necessary details that entails or that would have helped him to carry out his duty remotely as a result of the COVID-19 pandemic. It's as a result of this that our client that it rendered it impossible for the performance of his duty. Hence, an exemption to the fact that he is not entitled compensation, and in this case should be given compensation or remuneration or salary, because the contract which guides their employment still exists and was not terminated. Secondly, the issue of force majeure, which is a situation where the parties are exempted from obligations as a result of issues beyond their control, like in this case, the COVID-19 pandemic. However, one factor that you can't say should be an exemption of the principle of force majeure to apply is the presence of negligence. The HR manager, a representative of A and B company, failed to take proper precaution and proper care. She failed to do what any reasonable man in her position would do by communicating and ensure that all staff of the company are in the right position. Because of this, our client was unable to perform his duty, and her action could be termed as negligent. So with this, the principle of force majeure cannot apply because of the element of negligence on the part of the HR manager. Secondly, our client is entitled to damages. This is because one of the aim of damages is to put the client in a position that he was before the breach of contract. Looking at the fact of the case before us, it is clear that there was a breach of contract. And there was a breach of contract between the employer and the employee. And this is where damages come in. Mr. Musa, my client, resigned from his work, and it's also evident that he has family, and there is need for him to have a source of income to help cater for his family. The non-compensation and the lack of remuneration on the part of A and B company puts him at a loss, or put him at a situation where he is not able to take care of his family or to handle things. Also considering how difficult or how extreme the lockdown or the COVID-19 situation was. The position that the non-remuneration of the company has put him could be regarded as a great loss to him. It is on this ground that we say that our client is required or is entitled to damages, because the contract is still in force and was not terminated by either of the parties, and the non-performance of the company put him in a loss, therefore making him entitled to damages. Thank you, Madam Arbitrator.
Okay, thank you, Ms. Tofumi. Counsel to the respondent, do you have any rebuttal to all that has been said so far?
Yes, Mr. Arbitrator, I would still want to stand on the point that Mr. Musa is entitled to no remunerations, salaries, or damages at all. Thank you, Mr. Arbitrator.
Okay, and counsel to the claimant, you can give your closing statement.
Thank you very much, Madam Arbitrator, for this wonderful opportunity to hear my case, or the case of my client in this proceeding. As established, we have shown this, or I have shown this panel, that our client was not in the wrong. As a as a result of the lack of communication on the part of the employee, which is very evident in this case. Secondly, the principle of force majeure will not apply to our client because of reasons or factors beyond his control, and that is negligence on the part of the HR manager. We have proven before this tribunal that our client is entitled to salary arrears, which because the contract is still in existence and not terminated. Therefore, the situation which the lack of performance, among other factors, as itemized by we, the claimant, shows that the claimant, Mr. Musa, is in a loss and is entitled to damages, as the aim of damage is to ensure that the affected party is in a situation or is put in a situation as he was before the breach or before the non-performance or before the dispute or whatever it may be arose. It is on this ground that I pray that I request that this honorable tribunal considers all the facts and evidence presented before her, or before it, and grants that my client, the claimant in this case, be entitled to salary arrears, and the damages, or the damage in the sum of 20 million naira be granted to my client, Mr. Musa, in this proceeding. Thank you very much.
Okay, thank you. Counsel to the respondent, you can give your closing remarks, your closing statement.
In conclusion, A and B complaint contends that Mr. Musa is not entitled to the claimed salary in arrears or damages. The lockdown and subsequent non-performance of duties absolved the complaint completely of all financial obligations to Mr. Musa. The complaint seeks the dismissal of Mr. Musa's claims and a resolution in favor of A and B complaint. Thank you, Madam Arbitrator.
Thank you. So I've listened to the arguments from both parties and your briefs. It's quite obvious that the key issues for determination are whether Mr. Musa is entitled to his unpaid salary for the period he was employed by the respondent, but unable to work due to the lockdown, and whether Mr. Musa is entitled to the claim for damages. With regards to the entitlement to unpaid salaries, the employment contract between the claimant, Mr. Musa, and R&B company, the respondent, was indeed validly entered when Mr. Musa accepted the offer and completed his documentation. However, the fact that the lockdown COVID-19 occurred after Mr. Musa had already resigned from his previous employment and was ready to commence work at the A and B company does not negate the employment relationship. The claimant's inability to work was obviously caused by the lockdown, which was outside his control. And the respondent did not provide adequate information to the claimant regarding the remote work or alternative arrangements during the lockdown, despite the general manager's assurance that such instructions would be provided. The respondent's argument that Mr. Musa did not work is thus weakened and is not entitled to salary is weakened by the fact that he was ready to work and he was ready and willing to work, but sadly he could not commence work due to the lockdown and due to the failure of the company to inform him on how properly he is expected to work remotely. Therefore, the claimant is entitled to his salary for the period of his employment, as his non-performance was not his fault. With regards to the claim for damages, Mr. Musa requests 20 million naira Mr. Musa's request for 20 million naira is excessive and quite unreasonable. The respondent's failure to communicate during the lockdown, due to the respondent's failure to communicate during the lockdown. So the request for 20 million naira is just unreasonable and excessive. Well, based on all these arguments and issues raised, the tribunal issues the following award to the parties. one, that the salary arrears should be paid to the claimant by the respondent, and which is a sum of 1.6 million naira for the period from April 2020 to November 2020, representing the 8 months at 200,000 naira per month. And with regards to the damages, the respondent shall be entitled to pay the claimant a sum of 500,000 naira, which is a more reasonable sum to cover as general damages for inconvenience and hardship caused to the claimants for the non-payment of salary and the company's failure to provide clear communication during the lockdown period. Please note that each party shall bear its own cost of arbitration. This award is final and binding on both parties, and a written award will be presented to the parties soon. Thank you.
All right. Can you hear me?
Yes, sir.
All right. So I guess group one, you guys are done with the arbitration simulation, right? Okay. I assume you guys are done with your simulation. Thank you very much. But I expected you people to say you people have come to the end of your simulation, but it's all good. Thank you so much to the participants and those who volunteered to be a part of this arbitration. I sincerely do appreciate the effort you people put into the research, the time you people took to write your scripts, and everything that you did during this particular simulation. So well done to you and to those who put in the effort to represent on behalf of the group. Well done to you. So I'm sure Mr. Nyacham during the class seemed to during the simulation seemed to have a little issue with hearing those who participated in the simulation. I hope it was just for group one, and I hope he got to hear group two. But just to confirm from your end, sir, are you, sir? We would just want to hand over to you and see if you can give feedback to the simulation that was carried out by both groups, and anything you would like to add in the case of the processes and the way they handle the simulation. Mr. Nyacham, are you with us, sir?
Yes, good evening.
Yes, good evening,
So,
sir.
well, I want to start by
Are you still with us, sir? Hello, Mr. Nyacham, are you with us, sir?
Can you hear me?
Yes, sir, we can hear you
Can
now.
you hear me?
Yes, we can hear you now.
Okay. Thank you very much. So, let me start by asking the participants and those who presented. From all that they have presented, let's start by asking if any one of them have any question to ask.
All right. So Menzies, over to you. Based off of the simulation, is there any question you would like to ask as regards what you had and what you saw during the simulation?
And I think this is the last day of the mentorship, right, Mr.
No, sir. It's the last day for for arbitration for ADR, but we'll be having combined class with the other mentees in the other group in the subsequent week.
Okay, that's fine. So please, you've done the arbitration. This is the arbitration simulation. Do you have any question thus far from
Yes, sir.
your
Good evening.
research, from your preparation? Yes, please go ahead.
All right, sir. So I observed that during the arbitration, no legal reference or no judicial precedent was used. So is it that in arbitration we don't use cases, we don't use judicial precedents? Because we were talking about damages, and I know that damages are in contract, and there are a lot of cases that are in line with damages, but I didn't hear any judicial precedents on damages and other terminologies that was used during the arbitration process. So I don't know, sir.
Okay. That's okay. I think there is that's a good question. That's a good question. Whether there are no judicial authorities. Is that
Yes, sir.
whether there are no judicial authorities
Yes,
used
sir.
in arbitration? Okay.
Yes, sir.
Okay, that's fine. I'll attend to that. Next, is there any other question? Is there any other question? Hello?
Yes, sir, we can hear you. Mentees, please, do we have any other question aside the one that was asked?
So I think there's a question in the chat box.
Okay, thank you, Goodness. Okay, Goodness is asking, how exactly should an arbitration process take place? The structure, step-by-step process. So that's the question from Goodness. Did you hear that, sir?
Yes, yes. So, step by step. Okay, any other question? I think you should take advantage of the opportunity to ask questions. Okay?
Please, do we still have questions from our mentees?
Okay, if they don't, I wanted you to all ask so that in the course of speaking, maybe we'll pay particular attention to some of the questions. But if there is none, that's good. So in the course of your research and preparation, did you come across something that you did not understand? I don't know if you can hear me.
Yes, sir, we can hear you, sir. So please, for those who participated in the simulation, did you guys come across anything that was hard to understand, or probably something you did not get at all?
Okay, so if there is none, I'll ask the question. Okay, so now, well, maybe in the course of discussion, let me start by appreciating the mentees for a wonderful session. I will want to especially thank you for your time, for your research, your efforts, thus far from the beginning till this very time, and particularly to those who avail themselves to take part in this simulation, the arbitration simulation. For you to be able to have something to present, I believe that you must have made your research, you must have done, you must have made your research, you must have, practiced, I can see from those who have served as arbitrators, and particularly the last group that even went ahead to deliver an award. That's very, very. Okay, we have another question. Okay. All right. So having said so, arbitration is quite different from mediation, and so that you just have an idea how it is. I don't know how many of you have been in. I don't know if some of you, if you can put on your cameras, I would love to. Instead of feeling that I'm just speaking or talking to myself. If you can put on, if you're in a position to put on your camera, please do, please. Okay, well, Your Worship, thank you for coming on. Mary, you are hiding your face. Can you see? I didn't get that question you're asking. I don't know. Lucia Omanga. I don't get. You want to understand? What do you want to understand about jurisdiction?
Good evening, sir.
Yeah, good evening.
Okay, I want to know about bifurcation in terms of arbitration. For instance, if the respondent is raising jurisdictional issues, is contesting the jurisdiction of the arbitral tribunal in an arbitration proceedings, how does bifurcation comes in? Because I've handled like an arbitral proceedings before for ICC, that's the International Chambers of Commerce, and I was for the respondent, and we were contesting the jurisdiction of the arbitration tribunal based on the fact that parties had not exhausted amicable settlements before the claimant filed for the arbitral proceedings. And in the course of the case management conference, the arbitrator asked if we were submitting to bifurcation. I didn't really know what that was about because like that was the first time I was coming across what is it bifurcation meant in arbitration proceedings. And I was stranded at some point because I was the only one representing my clients for the case management conference. So I had to like do a quick search to know what it's about. I think the bifurcation was talking about they have to talk about the jurisdictional issue first before they delve into the main claims that the arbitration proceedings was instituted for. So I'm still not so conversant with the whole thing because I feel by the time we have like the next conference, and a question will still be asked in regards to that. So I don't know if like a clarification can come in on your part. Thank you.
Thank you, Lucia.
Okay. Okay, so which type of arbitration is that? What's the nature of what's the subject matter?
Oh, it's on breach of contract.
Okay. Okay. So all right. So do we have any other question? Do we have any other question? Okay, we do not have any other question. Okay, so now okay, so let's start from the beginning. Group 1. I don't know what made you feel that council can represent what made you feel that council can represent party in arbitration, like present on behalf of party.
Mr. Nelson, are you still with us? Okay, it seems he's having a little network issue. I'm sure he'll be joining us shortly. Sorry about that.
All right. Sorry, can you hear me?
Yes, sir, we can hear you now.
I was just wondering, as if I was talking to myself. I discovered that it is well. Okay. So okay, so for group one, I was asking, I say, what made you feel that a council can represent the council can represent a party, like make presentations on behalf of the party in a hearing?
So, please, I want to confirm something. I'm sorry for the interruption.
Go ahead.
Can I go on? Okay, the group one were I want to be sure which group we're talking about. We're talking to rather. Group one was the second group to present, while group two was the first group to present. So I don't know if your question is directed at the first group that presented or the second group.
I'm talking about the first to present.
Okay,
The
sir,
first
that's
to
group two,
present.
sir.
The first to present.
That was group two, sir.
Okay, go ahead, group two. What made you feel that you had council representing parties?
Do we have the members of group one who participated in simulation here?
Members of group one. It seems they are not here, right?
Group two, sorry.
Okay, group two.
I would like to answer the question, but it's based on like my own personal opinion, though, not like I'm answering for like the group, because I'm not so sure of the answer. During the course of the stimulation, the parties, I feel in their contracts, because there was a part where it says the parties want to like they want their legal representatives to represent them. So I feel number one, if they both agree and it's stated in their contracts, it can, their representative can represent them. And I also feel like it's more like I feel as if it should be based on how the parties are comfortable in like resolving their disputes. Personally, for me, I feel like they can ask anybody to represent them, just somebody who is aware of the fact of the case and who can express how they feel like their grievances to the arbitrator. Thank you, sir.
Okay, thank you for that contribution. Do we have any other person who wants to say something on that question? Okay. All right. So the thing is, in arbitration, what you do is what you do is upon okay, let me ask, what is the difference between preliminary meeting and pre-hearing meeting? Who will want to attempt? Will someone want to attempt?
So I feel preliminary meeting is like the stage where the parties and the arbitrator are getting to like know each other. This is where like they build trust. You understand? They try more like and maybe they like say like their introductions to be familiar with one another. While a pre-hearing stage is like the stage where the matter, should I say like the introduction of the issue at hand? Yes, that's what I feel it is.
Mr. Nyacham, it seems Mr. Nyacham doesn't really have a very stable network. We hope he is able to rejoin us back again. But well done to those who so far have been carrying on in the conversation, to those who are asking questions. We hope that eventually you are learning something, and that the class so far has been going well. Sorry about that. I just got through to him. He said he'll be re-entering the call back. Sorry, it's a little network issue from his end. So kindly bear patience with us. I'm sure all your questions will be answered, and eventually he'll be able to address those things that he has been trying to highlight. So thank you.
Okay, can you hear me now?
Yes, sir, we can hear you now, sir.
Okay, sorry, I had to check my connection. I don't know why the phone logged me out, and then I was wondering what really transpired. Thank you. All right, so I was trying to ask, I don't know who remembers the question I asked.
Sir, you said what's the difference between preliminary hearing and
Yes, preliminary hearing and pre-hearing, preliminary meeting and pre-hearing meeting, preliminary and pre-hearing.
Yes, one of the mentees answered that question. I think she was answering the question when you were logged out. She said for the preliminary meeting, preliminary meetings happen when the councils are trying to know themselves. While for the pre-hearing, they are trying to familiarize themselves with the case matter on ground.
Okay. Okay. Wow. I was just wondering if most of us attended, as the mentees really attended the session on arbitration, that we mentioned some important things and discussed them. So in as much as the effort they put is highly commendable, the presentation, but if they had some of the hints that we are giving, they will do much better. They have done well, but they would have done even much more better. So pardon, is someone speaking?
No, you can go ahead, sir.
Okay, so now for us to proceed, now in arbitration, in an arbitration scenario, before you can activate the jurisdiction, before you can start an arbitration proceedings, parties must have subscribed to arbitration in their agreements. So, and if it is a contract, if it is a business partnership, if you agree that, okay, goodness, can you hear me?
Sir, I can hear you from my end.
Okay, I saw Goodness. She said that she can't hear anything also. Goodness, can you hear me? Goodness, can Goodness hear me? Is any other person, can any other person hear me?
Sir, I can hear you.
Okay. All right. So now, okay, thank you. Jen, Mario, okay, thank you. Okay, so now, there must be an agreement that where a dispute arises, you are going to resolve that dispute through arbitration. And as we keep emphasizing, it is advisable for parties to agree to a pre-dispute mode of settlement, in case any dispute arises, than to wait until the dispute actually arose before you start thinking of ways to resolve them. So if you have, if there is an agreement already stating that you can arbitrate, then you commence the arbitration by issuance of, who can tell me, how do you commence an arbitration? Who? How do you commence an arbitration proceedings?
Okay, go ahead, Mr. Victor.
Yes, sir. To commence arbitration proceeding, of course, first of all, there should be an arbitration agreement. And when there is an arbitration agreement, to commence, the party that wishes to commence the arbitration proceedings will give notice to the other party involved. And after which they will now proceed to have to choose the arbitrators that will take charge of the arbitration proceedings. That's the commencement procedure.
All right, thank you very much. So where a dispute arose, if a dispute arises, what the party would do is to issue a notice of arbitration to the other party. And once a notice of arbitration is issued, depending on how comprehensive the agreement is, it will state the procedures. It will state the procedures that needs to be taken in the course of the arbitration. So if you issue notice of arbitration and then in it you said you are going to be appointing an arbitrator, it means that you suggest the arbitrator you want to appoint at the point of issuing notice of arbitration. So, but if it is an institutional arbitration, it therefore means that the parties will not bother themselves with all the other logistics, because the institution that is administering it will take care of all of those things. So when it comes to appointment of secretary and the rest of it, so the moment an arbitrator is suggested, and then you state the fact that in the event that the party did not respond, let's say within 7 days, it will be deemed that the arbitrator has been appointed. So if you have that, you deem that the arbitrator is appointed and the party fails to respond to the notice, in case if he has any issue with the suggested arbitrator, if it is a one arbitrator, fine. But if it is a panel of arbitrators, there will be no need, because the moment you suggest your own, party A suggests his own, party B will also suggest his or her own. Then the two appointed arbitrators are going to appoint the third arbitrator. That's if there is a panel. But if there is no panel, it's just a single arbitrator as suggested by group 2 when they were presenting. They said it's going to be governed by the Mediation and Arbitration Act, Arbitration and Mediation Act 2023. It therefore means that there is no there is going to be one arbitrator. That's the default number, and that arbitrator, upon the suggestion, if the other party did not respond within the time allocated, the arbitrator can take up his position and then send in his letter of acceptance, and then a notice of non-disclosure. You are indicating that you do not have any personal interest, you don't have any relationship with the parties. You send it that you have accepted the appointment. Now, I hope we're all together. I just want us to have an understanding of the processes so that you can begin to look at, did you miss something? Did you do something? I hope we are together. Give me a thumbs up if we are together. Okay, thank you, Chuku. Yes. Okay. Jemari. Yes. Just two people. Mary. Yes, thank you. All right, thank you very much. Only three people. I think only three people are with us. Only three people. Okay, your worship. Okay, thank you. Naid. Thank you. Okay. Okay, Adeton. Okay, thank you. Yes, okay. Banika. Okay, thank you. You're with us. Okay. So at the point of being appointed, what you do is you send what? Can someone mention? What do you send? What do you send when you are appointed? Nobody is speaking. Or you want me to just talk? Aha. Okay, letter of acceptance and the notice of non-disclosure, as in you are disclosing whether you have any affiliation with the parties or not. Thank you very much for that. So once you have accepted the appointment, what you need to do, the first thing you need to do, thank you, Lucia. The first thing you need to do is to now call a meeting. What is the name of that meeting? After you accepted the appointment, and let's say appointment is okay and confirmed, you call for a meeting. Okay. Yes. Any other person? Okay. Lucia, the two people very active. What is that meeting called? Okay, two people said a preliminary meeting. Yes. Now, your preliminary meeting. Yes, thank you, Naid. Your preliminary meeting is the first meeting the arbitrator is going to be having with the parties. And if the parties have representatives, they are going to come along with the representative because except if at the inception of the arbitration, if it is a lawyer or the legal representative of any of the parties that actually initiate the process on behalf of his client, then of course you will communicate with that person. So at the preliminary meeting, you are going to be looking at you have an agenda. And that meeting, you are going to get to know the parties, you are going to get their legal representatives, you are going to get those who are going to be representing them in the course of the arbitration. So you now have the arbitrator, the counsels or or their parties, at the table. Now, what are the major agendas among several others that you need to consider? You need to look at one, you want to confirm your appointment. You want to confirm that you are duly appointed. So confirmation of the of the appointment and also jurisdiction of the arbitrator will be confirmed at that preliminary meeting. So, okay, I have been appointed as the arbitrator. Is that okay with you? Is that okay with you? They say, yes, we appointed you. Go ahead. Okay, so my power or the jurisdiction I have is to decide in respect of so matters. Say, yes, that is it. They all confirm, isn't it? And after that confirmation, what you need to present is the appointment of the registrar and the secretary. That's supposed to be another thing that you consider at the preliminary meeting. So that's part of your agenda. Now you will get the CV or the summary of the profile of the proposed appointed registrar, either one or an secretary. Registrar and or secretary. or registrar and secretary. So once you present it to the parties, okay, upon my appointment, we need the services of a registrar. I have proposed Nahid Abdallah as the secretary. She is an associate of Settlement House Area Training Institute, and she has experience and understanding the process of arbitration, and her CV has been forwarded to you. And then look at her CV presently here, look at it. If you confirm the appointment of the registrar. So if they have confirmed the appointment of the registrar, fine and good day, appointment is confirmed. Are we together to this point?
Yes, sir.
All right. So now, once you confirm appointment, there are other important issues that you need to consider. Then if you are not doing the arbitration pro bono, you want to confirm your fee, you need to agree as to the fee of the arbitrator or the panel of arbitrators. You also need to agree on the fees for the legal fees of the registrars and secretaries. You have to agree and discuss and agree, so that those things that you discuss and agree, the language of the arbitration, the seat of the arbitration, among several other things, right, are going to be discussed at the duration. Who is going to, do you need the services of an expert, right? Which type of hearing are you going to conduct? Is it documentary? Is it oral? Is it oral and documentary? Which type? All these things are issues that you decide during the preliminary meeting. Then when it comes to filing of processes, will there be need for you to go for a visit? The lawyers call it locus, visit to locus where? Locus inco. You want to go and see the scene of the crime according to police and other people. You want to go and see the subject matter, if there is need. You have to confirm, is there need for us to call an expert? Is there need for us to visit the locals? All those things are part of your preliminary meeting. The language of the arbitration. Do you need an interpreter? You are going to decide all these things, right? These are things that you have to decide. You need an interpreter. Yes. These are agendas among several other things that are important. Where is going to be the venue? Is it going to be a virtual hearing or a physical hearing? Where is the venue? So administrative charges, if it is ad hoc, then you are going to make arrangement. We are going to be meeting in this hotel, and those are administrative charges. Then you want to ask, how do parties, how are they going to be served? What will be the proof of service for you to say that, yes, this person has been duly served? So are there communications? How do you communicate? You communicate with the registrar, you have phone numbers, you have WhatsApp numbers, you have email addresses, you have posting. Are you going to use all of them, or you adopt a particular one? And how do you show? What evidence do you need to show that, yes, you have actually served these other parties? Because processes are going to be exchanged. You are going to serve it all on the parties involved. Are we together to this point?
Yes, sir.
Yes. So
Yes, sir.
Thank you. So once you're able to decide all of these things and you agree, there are several other things that you may discuss depending on the circumstances. In fact, sometimes you may need to give maybe an emergency order to preserve the rest. Let's say there are perishable issues, or there are issues that maybe you need to give an injunction and all of those kind of things. All those things you decide at the preliminary meeting, among several other items that are important. So when you are done with the preliminary meeting, you are going to now, I heard one of the persons saying that within 24 hours, the record or transcription of the proceedings will be sent to parties. That's a good one. So at the conclusion of the preliminary meeting, the arbitrator is going to give them a summary of what was discussed during the preliminary meeting, and then he's going to issue his preliminary order number 1. And now he will now state, it will be that he has ordered, based on our conversation, you said that the language is going to be English language. You will give an order to that effect. You are going to need an interpreter that will interpret from English to Chinese. You know, that's an order that is given. You know, after summarizing it, you give an order. We are going to be using virtual hearing. We are going to, okay, you need to pay like 75% of the fees of the arbitrator, you know, within so period of time into so account number. You state it there. Oh, administrative charges, you know, this also hotel is going to be used as a venue, and then administrative charges should be paid for so amount of money, and then the registrar and secretary will take charge of that. All those things are going to be part. Those things you agree and discuss. You are going to give an order to that effect. That will be your first order that you issue as the arbitrator. Then after that one, you are going to call for a pre-hearing meeting. The pre-hearing meeting is the meeting where you are going to be crossing your T's and you are going to be putting a dot to your I's. All the orders that you have issued, you want to confirm. Your worship has given an order that party should be served. Then the first thing they come to the court, you want to confirm, has party A or B been served as ordered by the court? They say, we have not. So I say that's a disobedience to the court order. Maybe your worship will send the prosecutor to prison for disobeying the order of court. You know, that kind of a thing. So the arbitrator does not send someone to prison for contempt, but you want to confirm if everything you have ordered, processes that needs to be filed, you want to find out. We said that party A said he can file his process within 7 days. Party B said I will file. Party A said I will file my point of claim. Remember, it is not statement of claim, it's point of claim. I will file within 7 days. Party B says I will file my point of defense within 7 days. Then if party B has a counterclaim, he's going to file his counterclaim, you know, alongside with his defense within 7 days, and the claimant is going to respond to the counterclaim within 7 days. So when you calculate all of these things, you are now going to now take a date for hearing. So at the pre-hearing meeting, you want to confirm, have all the parties filed the necessary papers? Are all the parties on notice? The witnesses, you know, that are going to be called, are they available? You know, the expert that are going to be called, you know, is everything set? That is the essence of your pre-hearing meeting. If there are things that are not, let's say they have done everything, but they have not paid the fee, the first the installment that they are supposed to pay, you will now say, okay, you have to give them another time. You don't need to go and do the arbitration later on. As the arbitrator, you'll be pursuing the parties to pay you your fee, right? So you need to agree on all of those things at the pre-hearing. You need to agree at the preliminary meeting. Then you are going to do a pre-hearing to check all that you have ordered and directed, if they have been complied with. If everything is okay and the coast is clear, then you can now adjourn the matter for hearing. You can adjourn from preliminary meeting to hearing, but you can decide to say, okay, we are going to meet for pre-hearing so that we'll confirm if the date we fix for hearing is going to be visible. That will be your own duty as the arbitrator to decide. Are we together to this point?
Yes, sir.
Are we together to this point?
Yes, sir.
All right. Now, at the hearing, this is what happens. If you have been to a court session, if you have been to a court session before, the arbitrator sits. Now, if you have counsel, first, you should know that a counsel cannot come and testify on behalf of his, assuming you are doing an oral this thing where a party needs to adopt processes, needs to, except if it is documentary, the lawyer can appear there. But if you are going to do a normal trial, a lawyer, a legal representative should not appear. Okay, now, who are you going to cross-examine? Who do you ask question if the lawyer is the one that is giving the evidence? So he has the right to be every party has the right to be represented. In fact, they can represent themselves. But if you need counsel who represent you at arbitration, his duty is not to come and testify on your behalf. It's not like mediation where you just give letter of authority and then this one you are calling experts. When they testify independently, they are going to be asked some questions, they are going to be cross-examined. So if a party A, like in this case, the Mr. Musa himself should be there to give evidence, so that after his evidence, there will be an opportunity for him to be cross-examined by counsel from the other side. And if in the absence of counsel, party B should be able to ask questions. So what is the procedure? You come at the table and you introduce yourself. My name is Nanchang Nangwang, because this is not the first time you are meeting, but this is the arbitration. You must have introduced yourself. I take it for granted that you understand. Arbitration is more formal than is more formal, and it has almost all every resemblance with arbitration, with litigation, except that you don't use wig and gowns, and then you don't the rules of evidence. The evidence does not apply to arbitration, and then all of those objections as to documents and all of those things, it does not apply to arbitration. It's a formal, informal process, a formal, private way of resolving dispute. So at the hearing, you just introduce yourself. Maybe you must have known yourself. You announce your appearance. Okay, they already know you as the arbitrator. I had somebody arguing that it is a court in the course of presentation. It is not a court, right? That's why you need to know how you address the arbitrator. You need to know at the inception, my name is Nanchan Nangwan. You can address me as Mr. Nanchan. You can address me as Mr. Arbitrator. You can address me as arbitrator. Simple. Counsel on the other side will announce his appearance for party A. I am N. Nanchan ESQ. I appear for counsel party A, and then I appear for party A. Party A also will state, okay, I am Mr. Musa. Party A also will represent himself. Okay, my name is Mr. Musa. I am the claimant in this case. Then you go to the other side. I appear for party B. My name is N. Nanchang, ESQ. The party also will stand up. Okay, I am Mrs. Musa. I am the respondent in this case. You have introduced yourself and you are taking note of how. Remember, if someone says that, you should address him as Malam Nanchang. Ensure that you address the person as Malam Nanchang, because if you call him any other name, he may not be able to respond, and then maybe, and if somebody has struggled so much and acquired a PhD and he say his name is Dr. Nanchang, so please take note and ensure that you write it somewhere. When you want to call him, check your note and say, okay, Dr. Nanchang. Ensure you call him the way he wants to be addressed. Somebody who is married, instead of Mrs., they say, just call me Miss, or just call me my name. Please try as much as possible to obey and do the needful. So after that, if you want to do an opening, let's say if you want to do an opening, this thing, the counsel is going to introduce the matter, counsel to the claimant. This is a matter for breach of contract, and then my client has filed the necessary papers. We are claiming against the other party for this, and this, and then in the course of the hearing, we are going to make things available. Remember also at the preliminary meeting, you must have agreed on some of the documents. There are documents that you must agree on. Yeah, like in this case, I don't know whether you have even looked at documents. What are the necessary documents that you need to prove? Number one, the letter of employment is important to show that, yes, he was actually offered employment, right? Maybe copy of email address, or anything that can show that, okay, there is a communication between them and all of those kind of things. I've written a letter of demand to them to say this, and this, and they did not respond. All those things are things that you should have as evidence, right? So after the introduction, you are going into the hearing proper. Each party have introduced, okay, we are saying that no, we are not liable for this matter. We are not liable in this matter. My client is going to prove this, and that. Then you go into hearing. You can just go straight into hearing. Now you have the registrar. The registrar will there. The evidence that will be given will be on oath. So you now have party A. You now have party A. Okay. Arbitrator will ask party A, are you ready to proceed? Say, please proceed. The witness goes, stands up, and then he's giving evidence. He must have filed his document and his paper, just like they do in court. Okay, you have filed your point of claim, and then there are documents. You can help him identify in paragraph this, you mentioned so, yes. Paragraph this, you made mention of so. They are all before you, because you must have served. Everybody must have. If there is any contention, imagine if there is an issue as to, yes, this person has been, I think, okay, one of the things that you need to settle at the preliminary hearing is every document that is relevant, every information that is relevant to the matter. You ensure that you have it. So if they say there is a contract document or there is this, all of those things they should make available to the arbitrator. So at the hearing, all of those things that have been agreed. Imagine a situation where a party is saying, no, there is no way, I've not even employed him at all. You see that issue has to be sorted out first before you go further, because they are saying, no, we do not employ him at all. If they say we have employed him, they are attaching letter of employment. Yes, we employ me, but because of this, we cannot do this. The other person is saying, yes, this is letter of employment. This is my resignation from my place of employment, and all of those things. Those are documents that you may use in the course of it. So if you have your statement on oath, and then in stating that, okay, this and this and these are documents, you highlight them. At the end of it, your evidence is adopted. Let it be used as before the arbitrator. Now, after you present those documents, which the other party are already aware, they must have studied and prepared, you now ask them if they have any question for Mr. Musa. Mr. Musa will stand up and say, okay, counsel to the respondent will stand up and begin to ask, okay, oh, you said you are employed. Yes, you are employed. Okay. Did you resume? Oh, yes, no, I have not resumed. Did you actually work for this company? You say, oh, yes, I've worked. Oh, no, I did not work. Okay, and all of those things, you are going to ask questions that will help establish, okay, you will help discredit his own evidence and whatsoever, right? so that the arbitrator in the course of it will get to know the truth. So after he's done, it's the same procedure you repeat on the other side. It's the same procedure. So you are going to be asking the person, the party B, Mrs. Musa will go to the place. I heard one say, Mr. Musa saying in the proceedings that it was malicious, that she wants to have a malicious relationship with him. And then he refused or something like that. So all those things will come when you go on your own story. You have already written it down. Yes, you identify some of the documents that will be in support of your matter, and then highlight them, and then you now give the opportunity for the claimant's counsel to ask the questions, that if he has any question or cross-examination. Then at the conclusion of it, you must have agreed also at the preliminary meeting. You must have agreed. Please let me know that I'm speaking to someone. Am I speaking to someone?
Yes, sir, we can hear you, sir.
Okay.
Yes.
Yes,
Okay,
sir.
thank you. All right. So now, after every part has testified and the cross-examination has been done, if there is a witness, a specialist that you call as, he also come and give his evidence, and each of the parties are going to cross-examine the professional that was appointed. So at the close of it, at the preliminary meeting, you must have agreed that you are going to have a closing remark, more or less a final address. You address the court. And when you are addressing the court, what do? You are forming an issue for determination. From the facts presented before this tribunal, we are convinced that from the facts presented, is the claimant entitled to his claims? Maybe that's the question you ask. So you start addressing those issues. What makes you feel that the claimant has established? You say, first, there is a contract between the parties, right? There is a contract, and the contract clearly states the terms and conditions of the employment, right? So now, terms and conditions of the employment has been sorted out. Okay, now based on this thing, he is going to be paid 200,000 naira per month, and he has actually accepted the employment. He has resigned his place of employment. These are arguments. Then the person that asks about whether judicial authorities are used very, very much. In as much as you have cases that has to do with breach of contract, but if you are able to get a case that actually happens in arbitration, in an arbitration proceedings, and is related to a breach of contract, that will be much more better. Because in as much as you are going to be making decisions, we are not depending on the law, but you cannot make a decision that is contrary to the provisions of law or contrary to public policy. Are we together? The person who asks the question. So you use judicial authorities very, very well. More so if they are arbitration related. There are cases both within and outside Nigeria that are arbitration related, and then they address some of these issues of breach of contract and all of those things. So you use them very, very well in arbitration. Now, assuming you are addressing 3 points, there is a contract. Okay, you are not saying, okay, there is a contract between, whether you have established, number one, there is a contract, number two, whether there is a breach of that particular contract. You now say yes. Upon resignation, and you came for you to resume, you were informed that you should not worry because of COVID-19, you'll be operating from home. but you waited 1 month, 2 months, you have not been paid salary, and you have not also been assigned the responsibility. You have made effort to reach out and nothing happened. You know, that is so you now say there is an agreement, a contract, and they violated the terms of the agreement. They did not pay the salary, they did not do this, and there is proof that they have not paid anything. So number 3, okay, there is an agreement, there is a violation. Are there likely consequence for breach of contract? Say yes, you are going to say there is likely consequence. This is what the law says. This is what authority says concerning breach of contract, and then you need to compensate this person commensurate to. So is this person entitled to say yes, he has been appointed, he has been given letter of resignation, is available to work, he has resigned from his work in summary, he has resigned from his work. Now you breach the contract, he has suffered damages, you know, he has not been working, he could not take care of his family, he has just, doing nothing. Is entitled to damages. If there are cases that you want to support, that can support you in that, that is what you do. You are bringing to the attention of the arbitrator important issues that the arbitrator should consider while making his decision. That same thing is going to be, that opportunity will be given to the other party. You will also have opportunity to make his own closing remark, draw the attention, raise an issue for determination, highlight important points that the arbitrator should consider, and at the end of it, both of them are asking the court to grant their reliefs or to dismiss the reliefs, or with substantial cause, or and all of those things. So that is the step-by-step procedure in arbitration. That is what you need to know. And then with this, I think it has addressed most of the issues and matters that you needed to know in the course of. Then someone was asking, at what point do you transition to mediation, from arbitration to mediation, from mediation to arbitration? Now, where there is a dispute resolution clause that is comprehensive, and then it starts with the parties are going to discuss. They are going to try to negotiate and settle the matter between themselves. And if they did not settle, if they fail to settle, then they are going to, if they fail to settle, they are going to go for mediation. And if mediation fails, they will now go for arbitration. When you have these clauses, now even if you are at the arbitration table, parties can decide to go for a mediation. They can go and negotiate within themselves. Even a mediation itself is an assisted negotiation. So the negotiation could be with or without the assistance of a third party. If it is without the assistance of the third party, you call it negotiation. If it is with the assistance of a third party, you call it mediation. You call it mediation. If it is with the assistance of a third party, you call it mediation. Okay, so are we together to this point?
Yes, sir.
Are we together to this point? Okay, so now on the issue of transition from mediation, if the parties fail, because you see in mediation it is the parties that decide, the mediator is there to assist them. When they fail, they can go for arbitration. Arbitration, it is the arbitrator that decide. So even in arbitration, what sometimes arbitrators do is the fee is, for example, 10,000 naira. You tell the parties that if you resolve your dispute after the preliminary meeting, you are going to pay 10,000. You are going to pay 5,000. If you resolve it after if you resolve it maybe after arbitration has commenced, you are going to pay 75%. That's 7,500. If you did not resolve it until I deliver my award, I will collect my complete fee. So at any point in time, parties can decide to say, okay, wait, let us go and discuss and settle. And if the parties settle, their terms of settlement, according to AMA, can be enforced as what is called consent award. They are going to write what they agreed as their terms of settlement, and they will bring it before the arbitrator. When they bring it before the arbitrator is going to adopt it as his award. But in that case, he's not going to state the reason. So now at the conclusion of everything, hearing has been made and concluded. The arbitration has been concluded. You take a date for you to write your award as an arbitrator and publish it. Publishing may not necessarily mean parties coming back, then you sit down and be reading the award to them. It could simply mean that when every condition precedent necessary for the delivery of the award is met, including the fees, you are going to now publish the award. You send copies to the parties, and that concludes your assignment. It means you have published the award, you have delivered your award. That is the conclusion of the process. Now, when someone was asking about okay, can you hear me? Hello, can you hear me?
Yes.
I was calling on Lucia because she was the one that asked, that asked the question, and I wanted to confirm if she's here for if she's available. Okay, Lucia, can you hear me? Okay. Now, bifurcation, as I was saying, has to do with you are trying to separate the session into two, so that first you are going to discuss exhaustively the issue of jurisdiction at the first stage, which is very, very important and critical. So now all right. So Lucia, when you divide this thing into two, if you divide it into two, you address the issue of jurisdiction squarely at the first stand, at the first phase. If every issue that has to do with contention with the issue of jurisdiction, we did not submit. There are issues that has to do with the jurisdiction. According to our law, any issue on the jurisdiction should be raised, and then the arbitrator has the right and the power to rule on his own jurisdiction. So anything you are going to be talking as regards the issue of jurisdiction, the arbitrator has the power to rule on it. And the reason why these things are done, they are simple. Without jurisdiction, you cannot proceed to do the main case. Without jurisdiction, you cannot proceed. Without jurisdiction, you cannot proceed to do the main matter. And so, because of that, you need to first establish that you have jurisdiction first. When they are raising jurisdiction, they are raising objection as to your jurisdiction. Just like in the court of law, you have to first of all rule on your own jurisdiction, because that is the life wire of the arbitration. You cannot proceed with arbitration when they are questioning that you do not have jurisdiction, or that somebody is telling you that there is not even dispute in the first place, right? So the essence of it will make your work very clear and clean. It will reduce cost and wastage of time. It will see that once you are able to address the issue, you now proceed, and then it makes it makes the issue of jurisdiction, because when the arbitrator rules on his own jurisdiction, he will state the reasons why he feels that he has jurisdiction, and then it will set the course very clear for you to proceed with the necessary thing. But the only issue with that issue of with this bifurcation is that the procedural complexity. That's one of the issues. Because you are now leaving the issue of the main matter, the main merit of the case, the main issues that are of concern, to go and start doing is like in criminal law is like trial within trial. When the party is objecting to the statement that he made, that he did not make it willingly and it was not voluntarily, you go to trial within trial in order to establish the fact that yes, this thing was taken voluntarily. You start calling evidence. So it is a trial inside trial. You mean you left the main trial, you are now doing a trial inside a trial, just to establish the fact that you just want to establish the fact that the issue of jurisdiction. Then when the issue of jurisdiction has been established, the arbitrator also has the jurisdiction. He also is certain that yes, he has jurisdiction to proceed. That is it. So what do you do if you want to do bifurcation? For bifurcation, a party must make a request for it. And then when you make a request for it, you do whatsoever argument you want to present. Then the tribunal will decide, yes, okay, let us go on in. Then when you make a request that you want to go into bifurcation, and then the tribunal say, okay, fine and good. Go ahead. We can go into it. Then after all your argument and submission, you are not going to make you are going to the tribunal is going to make a ruling or a decision or a ruling based on what you presented, and then afterward you can now proceed into. But this verification that you see is mostly involved in international commercial arbitrations. Mostly it's international arbitration that you see some of these issues, more of these kind of issues. And the institutions that actually do those kind of things, the International Chamber of Commerce, the London Court of International Arbitration, ICSID, among several others. Those are there. Then on CITRAL, majorly, and CITRAL is the United Nations body for all of those things. Those are some of the institutions that take care of, actually uses some of the procedures. Lucy, I don't know whether that has been of any help to you. Lucia. Lucia. I see. Okay. I wish parties, we are not seeing you. Nobody is talking. You are not talking. It makes it look somehow. So, Mr. Samuel, you are welcome. Please, do you have something you want to say or add to what we have said from what you have seen and observed, so that we can conclude?
Good evening, Prof. Nachang. Good evening, everyone. It has been very interesting listening to your very rich and insightful presentation. I must thank you for all you do for the ADR world, and we know the Almighty will reward you. It will not make sense to add anything to the much you have said, but rather I may just want to speak to everyone on the call. The best you can do is to take the much you can take and do some research on your own. There's beauty in what you hear. There's also beauty in what you discover. We know that we are all responsible for the outcome of our lives. So please take time, get the Arbitration and Mediation Act 2023, try and get the document. We may pass them across if we need assistance, and any other relevant documents we have. Try and get acquainted with different institutes and their rules. ADR is all about practice and practice. Don't just acquire knowledge and sit down there. It may lead to academic constipation. I discovered that the attendees for today's session is drastically reduced compared to the numbers we have last week. Let's see how we can encourage everyone to be part of this. I think this is the much we can say. Thank you so much, Prof. Nachang. Thank you to JIIPCC. And I hope we make do with all that has been said. Don't get distracted. Don't think it's too cumbersome. Don't think it's cumbersome. Accept them the way it is. Try and do research on your own. Very, very important. Do research on your own. Try and read materials. And this is just a step. And make plans to attend formal trainings. Formal trainings will also assist you to strengthen your skills, strengthen your capacities. Attend webinars, volunteer for different institutes and different assignments that is being done. And The sky will be your springboard. Thank you for the privilege and opportunity to be part of this. Prof. Nacho, thank you so much for your deep insight. We appreciate you. Thank you. I hope I was audible enough.
Thank you very much. Thank you. Thank you very
Thank you, sir.
much. Thank you
Thank you very
for
much.
that contribution. Uh um so I think in just a closing remark, if nobody has any other further comments, we have encouraged some of you to take advantage. I think I saw one or two persons who participated in a certification training. This thing that you are doing, you have a general overview, but it will help you in what you do. If you want to become an expert and you want to be a certified mediator, please, we have a training that is coming up next month. You can take advantage of it. For JIIPCC mentees, those who have participated in this training, this particular training, you have a special discount. In fact, you have 50% discount for this particular training. So, but the condition is that you must be a mentee of JIIPCC and you have concluded your program, successfully. You will be entitled to. It is a training that brings across different ADR practitioners from different parts of Africa and the world and Europe. So you are going to have a very big, good perspective. I think your worship at Nahid has the opportunity of attending, and then Mr. Jemari, he had the opportunity of attending the training. So for those of you who are interested in taking your career to the next level, please do well to be able to reach out to us. If you have any constraint, any problem, we are there to see how we can assist you to become who you want to do. We really appreciate the fact that you have created time. Some of you are students out of your busy schedule to be able to attend the session for all these 5 weeks. We really appreciate your time. If you need further assistance, in every other aspect, feel free to reach out to us and the mentors. And for Settlement House, we are available to see how we can assist you in any way that we can. So please remember to also like and follow us on LinkedIn, other social media. JIIPCC and Settlement House ADR Training Institute collaborated to bring this to you. So you do well to be able to tag them when you are making your post. Tag JIIPCC, tag Shati, tag your mentors, individual mentors, tag them also, by doing that. And then don't just go and post. If you can do well by following, subscribing, that would be a good thing. If you can do that and then you encourage your commentees to do so, that would be really, really appreciated. So thank you very much, Mr. Dennis.
Yes, sir. Thank you very much, sir, for that. For
Mr.
your
Dennis,
kind words. Yes, sir, I can hear you. Thank you so much for your kind words, and thank you to Mr. Samuel too also for the highlights you gave. You together with Shati House, right? ADR Shati ADR Training Institute, right? We have been able to bring this program to you, right, for the past 5 weeks that you have been with us, and it has been really nice, and it has been really wonderful getting to interact with you guys. But for our mentees, the program is not yet over, right? You still have week 6 and then week 7. For week 6, we'll be having a host of other classes that will be together with the other mentees in the other cohort, like in the other groups. So the further messages in relation to that will be sent to your group, and you'll be directed on what to do as regards to that. Thank you so much for your time. Thank you so much for making yourself available. I look forward to seeing you in other class. Don't forget to share what you've learned on your different social media platforms. Tag your mentors, tag Shati, tag JIIPCC, and we look forward to seeing you in the next class. Thank you to our mentors, Mr. Nyacham and Mr. Samuel. We really sincerely do appreciate your presence. We've come to the end of today's class. Good night, everyone, and enjoy the rest of your evening.
Thank you so much.
Thank you very much, Mr. Victor. Thank you.
Thank you.
Nahid.
We appreciate
Thank
everyone.
you, Mr. Samuel.
You're welcome.
Thank you, Worship. Thank you, Gypsy.
You're welcome, sir.
Yeah.